Hello, welcome to Partnership Law. So now we are in the second part of the partnership law, which is the obligations of the partners. Okay, so first is the obligations of the partners among themselves. So meaning, what are these obligations that uh, would arise in executing a partnership with respect to his partners? Okay, but before that, let's discuss this. What are these relationships which are created upon executing a contract of partnership? So we have this relationship among the partners themselves. Um, Next is the relationship of the partners with the partnership. Third is the relationship of the partnership with third persons. And fourth is the relationship of the partners with such third persons. Okay, so these are the relationships that would be created upon executing a contract of partnership. Now, when does the partnership begin? So, kailan ba nagsisimula ang partnership? Okay, as we can remember, a contract of partnership is consensual. So, it means that it is perfected upon the agreement or the meeting of the minds of the partners entering into that contract of partnership. So, therefore, as a general rule, a partnership begins from the moment of the execution of the contract. Okay, upon perfection of the partnership contract, as a general rule, the partnership begins automatically. But as an exception, it would uh, take effect. Okay, the partnership would begin at a later time if there would be a stipulation in the contract of partnership and in the written contract of partnership that it would take effect some other time. Okay, but if there is none, automatically it will begin upon the execution of that contract of partnership. So, the obligations of each partner with respect to contribution of property. So, as we have mentioned in the definition of the partnership, that uh, the persons entering into the partnership or the partners will, in order to create a partnership, will have to contribute to a common fund, money, property, or industry. Okay, so of course that will be part of the obligations of the partners creating the partnership. Okay, so they have to contribute at the beginning of the partnership or at the stipulated time the money, property, or industry which he may have promised to contribute. Okay? Kasi pag create yan ng nung contract of partnership, nung written contract of partnership, maka-state kasi doon na ito si A, mag-contribute siya ng 1 million pesos, si B, 2 million pesos, ganun. So, that would become an obligation for that person in entering a contract of partnership. Okay, so that person who promised to contribute will become a debtor to the partnership with respect to that promised contribution. Okay? So B is the partner will also be bound for warranty in case of eviction regarding to specific and determinate things which he may have contributed to the partnership. For example, as a partner promised to contribute a building, and for that building to be used by the partnership for the business. Okay, so yun ang promise niya, contribution. Okay, bibigyan tayo, for example, bigay niya yung commercial space niya contribute niya ang commercial space niya for the partnership para dun conduct ng business ang kanilang partnership. Okay? Doon nila i-conduct yung business nila. Okay, but of course, that the partner who contributes such building or commercial space will warrant that he really is the owner of that building. So, may warranty na yung partnership would not be evicted from that building. Okay? Na winawarrant niya na yung partner na nag-contribute, siya talaga yung may-ari ng building or commercial space niyan. Kasi, pag may iba na nag-claim, okay, may ibang tao na nag-claim sa building or commercial space, okay, and then, because of such claim, ma-evict yung partnership, then, the partner who contributed that building would be liable to the partnership. Okay. The partner shall also be bound or liable for the fruits thereof from the time they should have been delivered without need of any demand. So, it's the same principle nung sa obligations and contracts nyo, di ba? If I don't know if you could still remember, di ba? If the debtor has to deliver a certain thing on a specific date or time, okay, from that time, the obligation to deliver becomes due, then the fruits accruing from that certain thing to be delivered will go or will accrue to the benefit of the creditor. And in this case, in partnership, the fruits of the things to be contributed to the partnership from the time that that certain thing should be contributed will now go to the benefit of the partnership, and it would be it should be given to the partnership even if there is no demand made. Okay. Additional obligations: to preserve said property with the diligence of a good father of a family pending delivery to the partnership, and to indemnify the partnership for any damage caused to it by the retention of the same or by the delay in its contribution. Okay, so there are certain prohibitions. So of course there will be rules that should be followed in entering a partnership, okay, given under the civil code. So there is a prohibition with respect to an industrial partner. Diba? If you could remember, industrial partner is that partner who only contributes industry or service to the partnership and nothing else. Hindi siya nag-contribute ng money or property to the partnership. Yung service niya lang ang kinontribute niya. Okay, so as a general rule, an industrial partner cannot engage in business for himself. So hindi siya pwede na mag-conduct ng ibang business. And take note that any kind of business, bawal ang industrial partner na mag-engage. Any kind of business outside of the partnership, okay, bawal. So, absolute yung coverage ng kanyang prohibition. Any kind of business. Okay, remember that? But that is merely the general rule. Okay, the prohibition has an exception. Okay, pwede na engage into another business ang industrial partner if he is allowed by the partnership. If there is a permission. So, pwede. But kung walang permission, bawal talaga ang industrial partner na mag-engage into another business outside of the partnership. Okay, so what would happen if the industrial partner would violate this prohibition? Okay, the capitalist partners will have this remedies. By the way, capitalist partner meaning yung mga nag-contribute ng money or property to the partnership. Okay? So, ano ang remedy ng partners if that industrial partner will violate the prohibition to engage into a business for himself? Okay. First is the capitalist partners may exclude him from the firm with the right to damages. Okay. I-expel siya sa partnership. Hindi na siya magiging partner. And then, the other remedy of the capitalist partners is that they may avail themselves of the benefits which he may have obtained in violation of this provision with a right to damages. Okay, so kung ano yung na-profit ni industrial partner from engaging in that other business, okay, pwede yun mapupunta yun sa mga capitalist partners. Okay? And of course, in both remedies, may right to damages ang capitalist partners. Okay, may prohibition din with respect to a capitalist partner. Okay, the capitalist partners cannot engage for their own account in any operation which is of the kind of business in which the partnership is engaged unless there is a stipulation to the contrary. So the prohibition here, or the coverage of the prohibition, is not absolute but merely relative. Okay? So, kung sa industrial partner, hindi talaga pwede mag-engage ang industrial partner ng kahit anong business outside the partnership, sa capitalist partner naman, pwede siya mag-engage ng business outside the partnership so long as this business is not of the same kind as that of the partnership business. Hindi kapareha yung outside business sa partnership business. Yan lang ang prohibition. Okay? With regards to a capitalist partner. Okay? So, iba ang prohibition niya from the industrial partner. But, pwede naman, okay, as an exception, pwede na mag-engage ang capitalist partner even if mag-engage into another business ang capitalist partner even if that other business is the same kind of business as that of the partnership, if there is a stipulation to the contrary in their contract of partnership or articles of partnership, there is a grant or there is a provision or a clause allowing the capitalist partners to engage in the same to engage business outside of the partnership which is the same as that of the partnership. So what would happen if the capitalist partner would violate this prohibition? Okay, the capitalist partner must bring to the common funds any profits accruing to him from his transactions and shall personally bear all the losses. Okay, so kung ano man yung kinita niya doon sa outside business niya, then dapat dalhin niya yun sa common funds, sa partnership. Okay, mapunta yun sa partnership. Okay, so this contribution sa number 5, this deals with ilan ba dapat ang ano ba ang sharing nila ng partners. Magkano ba dapat ang i-contribute ng isang partner sa common fund? Okay, if there is no agreement on how much should the partners contribute, then automatically the partner should contribute equally to the partnership. Equal dapat. Okay, unless na lang if may agreement sila na hindi equal ang kanilang contribution, pwede naman. Okay, but if wala, the law will provide, or the law provides that the contribution of each partner must be equal. Okay, so it is not only at the execution of the contract of partnership that the partners will contribute. Okay? Pwede din contribute ang mga partners in case there is an imminent loss of the business of the partnership. Okay? So, kailangan nila ng additional na capital para masalba yung business ng partnership. Okay, so in this case, this contribution would become compulsory to the capitalist partners. Okay, hindi kasama ang industrial partner. Okay, contribution in case of imminent loss of the partnership business will be compulsory to the capitalist partners, but not on the industrial partner. But what would happen if the capitalist partner, even though he has the capacity to contribute, okay, he is able to contribute, but ayaw niya lang talaga mag-contribute, ano ba ang remedy ng ibang capitalist partners? Okay, so the remedy would be the forced sale of interest. Okay, pwede nila na yung interest ng capitalist partner na ayaw mag-contribute kahit may pang-contribute siya, kahit may pera siya na pwede niyang i-contribute sa partnership, then pwede na yung interest niya doon sa partnership would be forcibly sold to the other partners. Okay, so ito yung requisites niya. First is there is an imminent loss of the business of the partnership. Okay. Second, the majority of the capitalist partners are of the opinion that additional contribution to the common fund would save the business. So, majority lang. Majority. Okay, majority, kailangan ng majority vote ng mga partners. Ng capitalist partners rather. Okay? And then, the capitalist partner refuses deliberately, not because of his inability to do so, to contribute an additional share to the capital. So, kailangan daw, dapat, yung capitalist partner na ayaw mag-contribute is because ayaw niya lang talaga kahit may pang-contribute siya. Okay, deliberate ang kanyang pag-refuse to contribute. Okay, so it means that forced sale is not applicable if the failure to contribute is because of the inability to do so. Okay? And the fourth requisite is there is no agreement that even in case of an imminent loss of the business, the partners are not obliged to contribute. So dapat walang agreement na hindi makumpel ang mga partners to contribute in case of imminent loss. Because if it's otherwise, may agreement sila na walang walang compulsion, then um, of course, obviously, the partners, the other capitalist partners cannot compel the capitalist partner who refuses to contribute. Now, who bears the risk of loss of the things to be contributed to the partnership? Okay, sino ba ang magbe-bear ng risk of loss? Those things to be contributed and things contributed to the partnership. Okay, if the thing is not fungible, so meaning hindi siya consumable, and only its fruits, use and fruits are contributed, okay, it is the partner who owns the thing will bear the risk of loss. Okay, so ganito ang meaning niyan. For example, I will contribute, ako isang partner, we will execute a partnership. Okay, so magiging partner ako, and I promised or I contributed my my vehicle to the partnership. Okay, but the contribution is hindi ko talaga transfer yung ownership ng vehicle ko to the partnership. Ako pa rin ang may-ari, pero pinapagamit ko lang yung vehicle ko sa operation of the business of the partnership para may magamit ang partnership na kanilang service. Okay, so ako pa rin ang owner. In that case, if for example, the vehicle will be lost because of say for example, a flood, an earthquake, okay, a fortuitous event, as because of a storm, then I will bear the risk of that or the loss of that thing. So sa akin ang risk of loss. Okay, I will bear the loss of that vehicle. Okay, why do I bear that that risk of loss or that loss of the vehicle? It's because I am the owner. This article 1795 follows the principle that that it is the owner of the thing who shall bear the risk of loss. So it is a basic principle that whoever owns the thing is the one who should bear the risk of loss of the thing. So kung mawala man yan, ma-destroy man yung thing na pagmamay-ari mo, then ikaw ang mag-bear ng loss niyan. So this article, again, article 1795 just follows that rule, okay, in this case. Ito, the partner who owns the thing bears the risk of loss because he is still the owner of that that property contributed to the partnership. He is still the owner, and the only thing he contributed to the partnership is merely the use. Okay, not the ownership of the thing, but the use and the fruits only of that property. Okay? How about if the thing that is contributed is fungible? So meaning it is consumable. Okay? The risk of loss would be borne by the partnership, whether or not only their use and fruits are contributed. So this here is like an exception to the principle, the general principle that whoever owns a thing bears the risk of loss of such thing. Okay, it is an exception to that general principle, because here, even if Okay, in this letter B, even if the only the use and the fruits are contributed and not the ownership of that fungible thing, okay, it is the partnership that would bear the risk of loss. Why? Because it's fungible. Okay, it would be consumed at it will be totally consumed at a given period of time. Okay. Ma-consume kasi siya, nauubos kasi siya. So kaya yung partnership na ang mag-bear ng risk of loss. Okay? Now, how about if the thing contributed cannot be kept without deteriorating? Okay, so the thing contributed will to the partnership would be deteriorated. Would deteriorate at a certain period of time, will deteriorate until it would no longer be serviceable. So whether or not only their use and fruits are contributed, the partnership will bear the risk of loss. Okay, it's the same with B, letter B. Upon the partnership, if the things were contributed to be sold. Okay, so kinontribute siya ng isang partner para ibenta ng partnership. So again, this is an exception to the general principle that whoever owns a thing shall bear the risk of loss of such thing. And then, how about if the things were brought and appraised in the inventory? So as a general rule, it is the risk of loss is upon the partnership. Except na lang if there is a stipulation to the contrary. Okay, so take note that from letters B, C, D, and E, it is presupposed that the things that were contributed to the partnership have already been actually or constructively delivered to the partnership. So may delivery na. Because before such delivery, okay, before pa kung itong mga things are to be still to be contributed, hindi pa nabigay sa partnership, then it is the partner who will bear the risk of loss. Because before delivery, the partner is still the owner of that of the thing. Okay, so meaning if he is still the owner of the thing and the thing is still in the partner's possession, then of course that partner will bear the risk of loss. Now, with respect naman to distribution of profits and losses, so di ba, partnership, the partners will contribute to a common fund for the purpose of gaining profits and then dividing such profits among themselves. So, diba? Yun yung essence ng partnership. But how do they distribute these profits and losses among themselves? How do the partners do that? Okay, so first is if there is an agreement on how to divide this partnership, then that agreement how to divide the profit, then that agreement should be followed. Okay? So, if agreement nila is equal shares, or si partner A would have a share of 30% of the profits and also 30% of the losses, and then si B 20% sa kanya sa profits and also of the losses, So that agreement should be followed. Okay? Agreement nila sa division of the profits and losses. Now, if the agreement is only with respect to the profits, then the share of each partner in the losses shall be in the same proportion. So, kung agreement nila is sa division is profits lang pero silent on the losses, then the distribution or the division of the losses will follow the division of agreed as to or with respect to the profits. Okay? Follow lang ang losses. But in the absence of stipulation, kung wala talagang stipulation, then the share of each partner in the profits and losses shall be in proportion to what he may have contributed. So, depende na ngayon sa kanilang contribution. So, kung mas malaki ang contribution ng isang partner, obviously, mas malaki din ang share niya sa profits and losses. Okay, so if his contribution would amount to 50% of the capital raised by the partnership, then yung mapupunta sa kanya na profits or share niya sa losses would also be 50%. Okay, so in proportion siya sa kanyang contribution. Now, important rules to remember here is that an industrial partner is not liable for the losses. So, kung walang agreement, okay, in the absence of a stipulation as to the division of the profits and the losses, then the industrial partner would not be liable for the losses. But, of course, he would be entitled to the profits. Okay, so on how to determine the profits of the share of the profits of the industrial partner, because di ba hindi kagaya ng money or property na pwede siya madali siyang i-value. As for the industrial partner, the service contributed by the industrial partner would be valued, and from that value of his service or industry, then that would be the proportion of his share in the profits. Now, if besides his services, okay, the industrial partner, he has contributed capital, he shall also receive a share in profits in proportion to his capital. Okay, so therefore, kasi hindi na siya purely an industrial partner, but he also becomes an capitalist partner, then he would now be liable for the losses in proportion to the to his capital contribution, to the money or property he contributed to the partnership. No, pwede rin na ang sharing ng kanilang profits or losses be determined by a third person. Okay, pwede nila i-entrust sa third person. Okay, if the partners have agreed to entrust to a third person the designation of the share of each one in the profits and losses, such designation may be impugned only when it is manifestly inequitable. In no case may a partner who has begun to execute the decision of the third person, or who has not impugned the same within a period of 3 months from the time he had knowledge thereof, complain of such decision. Now, this designation of losses and profits cannot be entrusted to one of the partners. Of course, hindi pwede. Ang allowed under Article 1798 is ang third person, yung person outside of the partnership pwede mag-determine ng kanilang division or distribution. But hindi allowed ang isa sa mga partnership na mag-determine. Obviously, because of conflict of interest. Kung one of the partners will determine the the ano the the distribution of the profits or losses, of course, advantage sa kanya yung of course yung determination niya would become he will make it more advantageous for him. Okay, now take note that under Article 1799, a stipulation which includes or excludes one or more partners from any share in the profits or losses is void. So if they will agree that one of the capitalist partners will not be included in the share of the losses or the profits, then that that stipulation there or that clause in the partnership contract would be void. Okay, void siya. No, but with reference to the industrial partner, since the law itself, di ba, if you could remember, the law itself, okay, says that the industrial partner will not be, there is a provision in the law that exempting an industrial partner from the losses, then it could be that if there is an agreement not to include an industrial partner in the sharing of the losses, then that would be all right. Okay, that stipulation will not be considered as void. It would be valid. Now let's go to the management of the partnership. Now there are certain situations in which may happen in the management of the partnership. Okay, so first situation is that when the manager was or is appointed in the articles of partnership. Okay, doon talaga sa yung written contract of partnership nakalagay doon kung sino ang magiging manager ng partnership. Okay, another situation would be the manager was appointed after the constitution of the partnership. Okay, so hindi siya nakapangalan doon sa articles of partnership, but he was only appointed after the partnership has already begun. Okay, it could be another situation. And then there would also be a situation that no manager was appointed at all. No manager of the partnership was appointed at all. So in case that the manager was appointed in the articles of partnership, that manager may execute all acts of administration despite the opposition of his partners, unless he should act in bad faith, and his powers will become irrevocable without just cause or lawful cause. So hindi siya pwede matanggal basta-basta as manager without just or lawful cause. So dapat may just or lawful cause para matanggal ang isang manager. Okay, matanggal siya as such, as being a manager in a partnership, if such manager was appointed in the articles of partnership. Now, when Okay. Okay, how about when the manager was appointed after the constitution of the partnership? Then such power, okay, this power would be can be revoked at any time, even without just or lawful cause. Okay, so iba siya, di ba? Iba siya from from the manager appointed in the articles of partnership. Okay, so what about if there is no manager appointed at all? Now, all partners will be considered as agents, and whatever any one of them may do alone shall bind the partnership without prejudice to provisions of Article 1801. Okay, so they would all become managers. Each one of the partners would become the managers or agents of the partnership. So they can individually do all acts of administration of the partnership. So if we say acts of administration, it is merely those things which do not relate to the ownership of the ownership of the partnership. Okay, those which do not relate to acts of ownership, like selling the properties of the partnership. Okay, so it that is an example, or that is not included in the acts of administration. So if we say acts of administration, those merely which are connected or related to the ordinary running of the business of the partnership. Okay, or in short, the acts of administration refers to the to the management of the business of the partnership. Okay, so now let us go to the rights of the partnership. So tapos na tayo sa obligations of the partners. Now let's go to the rights of the partnership. So first is sub-partnership. So every partner may associate another person with him in his share, but the associate shall not be admitted into the partnership without the consent of all other partners, even if the partner having an associate should be a manager. So, for example, A, B, C, D are partnership in the partnership called X. Now, A, the manager of the partnership X, will now make another, or will now associate himself with another person, making him a partner with respect to his share, okay, with respect to the share of A. Let's say, for example, E. Si letter E. So, hindi ibig sabihin na associated si E kay A. Hindi ibig sabihin nun na si E is magiging partner na sa partnership X. Okay. He can only be included as a partner in the partnership X if all other partners of A would consent, okay, will consent to the inclusion of E to the partnership. Okay, so a sub-partner, the consequence of this is because hindi talaga partner ang isang sub-partner. Okay, the sub-partner does not acquire the rights of a partner, nor is he liable for its debts. Okay, so another right is to inspect the partnership books. Okay, the partnership books shall be kept subject to any agreement between the partners at the principal place of business of the partnership, and every partner shall at any reasonable hour have access to and may inspect and copy any of them. Okay, right, to inspect the partnership book. So what is the meaning of reasonable hour? It means reasonable hours on business days throughout the year, and not merely some arbitrary period of a few days chosen by the managing partner. So business days, reasonable hours on business days. So in the Philippines, ang reasonable hours na to in business days would mean Monday to Friday, 8 a.m. to 5 p.m. No. Yan ang usual na meaning ng reasonable hours on business days. The right to require information. The partner shall render on demand true and full information of all things affecting the partnership to any partner or the legal representative of any deceased partner or of any partner under legal disability. Okay, right to require information. Also, the partners has the right to a formal accounting, but take note, the right to formal accounting does not ordinarily exist during the period or the existence of the partnership, because the rights of the partners, okay, to know the partnership affairs are already amply protected under Article 1805 and Article 1806. So there is dito sa right to inspect partnership books and right to require information. The rights of the partner to information as to the partnership affairs are already protected from that. So therefore, generally, the right to formal accounting is not available during the existence of the partnership. Okay, but if these circumstances if any of these circumstances is present, then the right to a formal accounting will also arise. Okay, so if a partner is wrongfully excluded from the partnership business or profession, or possession of its property by his co-partners, if the right exists under the terms of any agreement, and then as provided by Article 1807, and whenever other circumstances render it just and reasonable. So these are the only instances, okay, these are the only instances in which the right to formal accounting is available. Okay, so they are merely the exceptions. The exceptions. The general rule is that the right to accounting will not be available during the existence of the partnership. Okay, ano yung Article 1807? Every partner must account to the partnership for any benefit and hold as trustee for it any profits derived by him without the consent of the other partners from any transaction connected with the formation, conduct, or liquidation of the partnership, or from any use by him of its property. So tapos na tayo sa rights of the partners. Now let us go to the property rights of a partner. So this is different. This is different from the rights of the partners. Okay. Property rights of a partners, we we must separate it from the rights of partners. Because specific siya kasi, enumerated under Article 18.10. Okay, the property rights of a partner are his rights in specific partnership property. Second is his interest in the partnership. And third is his right to participate in the management. Okay. So, isa-isahin natin. So, his right in a specific partnership property. So, under Article 1811, a partner is a co-owner with his partners of specific partnership property. Now, I know this provision given under Article 1811 might be a little bit confusing or problematic, because if we take it literally, or not literally, but if we follow the principle under the doctrine of separate juridical personality, okay, the partners will not become co-owners of the property of the partnership. Okay, because the partnership will have a separate juridical personality from that of the partner. So meaning the consequence of that doctrine is that the properties of the partnership will not be the properties of the partners. At the same time, the obligations of the partnership would not be as a rule will not be the obligations of the partners, and vice versa. The properties of the partners, okay, the properties owned by the partners are not the properties of the partnership, and the obligations of the partners are not the obligations of the partnership. Okay, so that is why this provision here is a little bit confusing, but that would not be this anyway, this provision here will not be that useful in answering problems in the partnership, so let's just take it as it is. Okay, another property right is his interest in the partnership. Okay, the interest of the partner in the partnership, that is his share in the profits and surplus. Okay, so that is his interest in the partnership. And then his right to participate in the management. Okay, so of course a partner has the right to participate in the management of the partnership, but it is subject, diba, as to our previous discussion, it is subject to the appointment of the manager, diba? If there is already appointed manager in the articles of partnership, or appointed manager after the constitution of the partnership, then that appointed manager will have the sole power to to execute all acts of administration. So wala nang hindi na pwede makaparticipate ang isang partner sa management. Ang partner na hindi appointed as manager, hindi na siya pwede makaparticipate sa management of the partnership. Okay, so that's it for the property rights of the partners. Now let us go to the obligations of the partners with regard to third persons. Third persons yan, sorry. Okay. So, kung kanina sa letter A, obligations of the partners among themselves yun, ito naman, obligations of the partners with obligation of the partners to third persons. Okay? So, first, under here is the partnership name. Every partnership shall operate under a firm name which may or may not include the name of one or more of the partners. So, dapat may pangalan ang partnership. Okay, those who not being members of the partnership include their names in the firm shall be subject to the liability of a partner. Okay, so hindi siya partner but in-include niya yung name niya sa partnership, then he would be liable to third persons. He would be as if he is a partner to the third persons who has believed that he is included in the partnership. So it follows, or it is under the principle of estoppel. Okay? Principle siya ng estoppel. He is stopped, or he is prohibited from denying his being a partner to a partnership if he has consented to put his or her name in the partnership name. Okay. For partnership debts, okay, important, please remember this. Okay, all partners, including industrial ones, shall be liable pro rata with all their property and after all the partnership assets have been exhausted. For the contracts which may be entered into in the name and for the account of the partnership under its signature and by a person authorized to act for the partnership. However, any partner may enter into a separate obligation to perform a partnership contract. So, di ba? Yung partnership may separate juridical personality siya. Okay, so ang kanyang obligation ng partnership as a general rule, hindi obligation ng partners. But ang sabi dito sa Article 1816, if the assets of the partnership has already been executed, has already been exhausted, okay, then the partners would be subsidiarily liable to the partnership debts, okay, to the obligations of the partnership. Okay, so again, the general rule is through the doctrine of separate juridical personality, the partnership would be the obligations of the partnership. Okay, kasi may separate juridical personality, it's as if tao rin yung partnership. So therefore, ang obligation ng partnership na yan will not be the obligation of the partners. But if in that obligation hindi na makabayad ang partnership and na-exhaust na ang properties ng partnership, then that obligation will go to the partners. Okay? Kaya, ang tawag dyan, kasi pupunta lang yung obligation ng partnership to the partners after exhausted na ang assets or properties ng partnership. Ang tawag dyan na liability is subsidiary. Okay? Subsidiary na ang kanyang liability. Only after the assets of the partnership has been exhausted may the partners be liable, be made liable to the partnership debts. Okay? Any stipulation against the liability laid down in the preceding article shall be void except among the partners. Okay, so void siya with respect to third persons. Okay, for example, A, B, and C, A, B, C, D, entered. Okay, ang partners natin ay si A, B, C, and D. Now, they enter into a partnership. So, therefore, may makikreate na artificial being. Let's say we call this partnership X. Okay, so let's think of it na ito si partnership X is para talaga siyang tao. Okay, artificial being with a juridical personality. Now, nagkontrata sila ngayon, si partnership X ngayon, kumontrata siya, okay, nag-enter siya into a contract, and then as you have learned, kung mag-enter ka ng contract, you will incur an obligation. May obligation ka. So, si partnership X, magkakaroon na siya ngayon ng obligation, let's say, to the other contracting party. Let's say, ang pangalan niya ay si letter E. Okay, letter E. Now, if on that obligation of partnership X, hindi na makabayad, okay, hindi na makabayad si partnership X, and then naubos na ang assets or properties ni partnership X, by virtue of this Article 1816, si partners A, B, C, and D would now be liable to E. So, C would be subsidiarily liable to E. Okay, so pwede na si E, the third person, okay, the third person will now collect for the partnership debts from A, B, C, and D. Now, if there is an agreement between A, B, C, and D that, for example, they agree that D will not be liable, subsidiarily liable for the partnership debts. Okay, may internal agreement si A, B, C, and D na hindi pwede maging liable si D to the partnership debts. That would be void, okay, from the eyes of E, okay, from the viewpoint of E, that agreement would be invalid. Okay, E can still collect from D the partnership debts. Okay, E can still collect from D the partnership debts even with the agreement or the stipulation in the articles of partnership na hindi na magiging liable si D. Okay, but with respect to the partners, among the partners, that agreement would be valid. That agreement that E will not that D will not be liable for the partnership debts would be considered as valid. So therefore, if maniningil si E kay D, and then of course makakabayad talaga si D to E, therefore si D pwede siya magpa-refund, magpa-reimburse ng nabayad niya kay E from A, B, and C. Okay, so that is the meaning of that Article 1817. Invalid siya kung si E ang para kay E, invalid yung stipulation na to, but para sa mga partners, valid yan na stipulation. Okay, liability to loss or injury caused to third persons. Okay, but if there would be injury caused to a third person by reason of the wrongful act or omission of any of the partners. Okay. The partnership would be liable to that to that third person injured. Okay. And then liability for misapplied money or property of third person. Okay, the partnership is bound to make good the loss. Okay, where one partner acting within the scope of his apparent authority receives money or property of a third person and misapplies it, and where the partnership in the course of its business receives money or property of a third person and the money or property is received is misapplied by any partner while it is in the custody of the partnership. It's just the same. So na-receive na yung money from the third person and the money was misapplied, then the partnership would be liable to that third person. Okay, misapplied siya by any of the partner. So take note here that the partners are solidarily liable for the partnership solidarily liable with the partnership for the liabilities here in Article 1822 and Article 1823. Sa liabilities diri sa loss or injury caused to third persons o liability for misapplied money or property of third persons, solidarily liable ang mga partners. So hindi na kailangan na i-exhaust pa yung properties ng partnership para masingil yung mga partners. Okay? If we say solidary, it means that the debtor, the creditor, or that third person can go directly, can demand directly from the partners, okay, as you have learned in your obligations and contracts. So, iba siya from this under Article 1816, the partnership debts. Kasi sa partnership debts, subsidiary ang liability ng partners, while in loss or injury caused to third persons and misapplied money or property of third persons, solidary ang liability ng partners. Okay, so that's it for obligations of the partners. Okay, so thank you for listening. See you again in the next video discussion.